Good morning, good afternoon, good night. It depends your time and your location. You are joining us today at Eastern News 24. As in the bike and konyo chili, yazelo. Nadi ko sidi, kaba pini osi uterunya bozi ya jimakia webia ni wakuko. Basta maka iya na bo matters arising on Nnamdi Kanu's court case. Before I go see ni ya jimakia webia, the ebe na oge gara aga. The former aide of President Buhari, wodi fo de na Twitter handle. O wee sị ọ na-asụ onye ọbụla na-aslapụ Nnamdi Kanu is an enemy of Nigeria. Na onye ọbụla na-ekwu slapụ Maazị Nnamdi Kanu is an enemy to Nigeria. Then o were ihe mee enu so were wee reply ya to him. Akwụwatago wee pịagodi ya a na-akpọ wọtọwọtọ. Because the question now, ị na-asị onye ọbụla napụrụ Maazị Nnamdi na-asị karapụ Maazị Nnamdi Kanu bụ an enemy of Nigeria. Or would if Maazị Nnamdi Kanu mere other than to seek for freedom of his people? No, that is the only thing Maazị Nnamdi Kanu melu. Boko Haram na-egbu ndị mmadụ ebe niile. Nobody is dying about it. Rather than they recruit them to the Nigerian army and nobody is saying anything. Ọ bụrụzi onye na-azụ for the freedom of his people. Ka ya na-asị na onye ọbụla na-ekwu for his ladies is an enemy of Nigeria. Then ya bụ ife akwụsị ebe ahụ. Ngegodi ya bụ ihe lawyer ya kwuru n'iru akwụkwọ gbasara maka ya bụ ihe. All right, over to you.
Made by the Southeast governors on 17 September 2017. And accordingly, following these public declarations by our government officials on 20th September 2017, late Justice Kafrati of the Federal High Court granted the federal government her wish in an ex parte application brought before the justice by the former Attorney General of the Federation, Abubakar Malami, SAN. Apparently, in taking the decision to prosecute IPOB and declare it a terrorist group, neither the Southeast governors who fired the first salvo nor the federal government had recourse to Section 42 of the Nigerian Constitution, which is a fundamental right, a section guaranteeing the fundamental right of every Nigerian against discrimination based on ethnicity. I'm saying this because later in time this matter went to court and the High Court of Enugu State in a landmark ruling pronounced the executive action or administrative action leading to that prescription as violative of Section 42 of the Constitution based on some ethnic considerations against the Igbo. Thus, by the plain provisions of that section, members of IPOB who largely hail from the Igbo tribe were generally criminalized. So to be clear, the practical application of any law enforced in Nigeria, including the Terrorism Prevention and Prohibition Act, or any criminal justice statute or legislation, has to be applied even-handedly across the board to all Nigerians without discrimination of any sort. But in this very instance, IPOB, having been perceived as springing from the Igbo and their cousins in the southeastern part of Nigeria, was singled out for the special act of discriminatory proscription and declaring it a terrorist group. Of course, this gave the federal government the legal license to direct its armed forces to resort to the rules of engagement, which required it to shoot to kill, not even shoot to maim anybody perceived to be a member of IPOB, and this has continued to this day. And of course, that was what culminated in the extraordinary rendition of Maazị Nnamdi Kanu from Kenya to Nigeria in 2021. It therefore follows that by failing to take action to proscribe other similarly related ethnic organizations, such as the Fulani Headsmen or Mietiala, or Odua People's Congress or Niger Delta Avengers, some of which are known to have borne arms and carried out violent attacks, but the federal government did not as much proscribe them or declare them terrorists as it did IPOB. It is our position, and which was confirmed by the court judgment I referenced, that the proscription was highly discriminatory. Now, in summary, the right guaranteed under that section is unarguably and essentially a right to freedom from any discrimination of any sort based on national origin or ethnicity, such as has been levied against the IPOB and its members, perceived or real, by the federal government since October 2017. The declarations made by the court are 3, and the orders issued 2. The court declared that action unconstitutional. It also declared that what IPOB is engaged in, the enterprise, is known as self-determination and that it is not unlawful. And the court, because the action offended its conscience, awarded $8 billion against the federal government for that action. It therefore came as a double whammy that in the next few days following the prosecution of IPOB, the Attorney General of the Federation underscored the constitutionally prohibited finality of the action by gazetting it, and therefore criminalizing millions of Igbos who are perceived to be members of IPOB, whether the perception is real or not. And it also led to interdiction of their properties, money, and otherwise wherever found. It's also led to mass arrests, extrajudicial killings, torture, detentions without trial, and whatnot. Now, in March 2018, the African Union, through its African Commission on Human and People's Rights, which administers human rights adjudications in the continent of Africa, held against the federal government that the proscription was wrong under the African Charter, which bound Nigeria. Nigeria ratified the African Charter in 1983, and from that date it is bound by it. So this African Commission on Human and People's Rights had clear jurisdictions to decide this case, and it decided against the federal government and the President of Nigeria to retrace his steps and restore IPOB to its former legal status and cease and desist from further arresting or harassing or persecuting members of IPOB. Yet, from the date of issuance of that decision to when the former president left office, nothing was done. Rather, the opposite was done. The persecution, prosecution, arrest, torture, everything became even worse. It is pertinent to mention at this juncture, perhaps as a necessary digression, that had the former president of Nigeria implemented that directive issuing from the African Union, a lot of people who died, numbering in the hundreds, some say in the thousands, and in fact, including Nnamdi Kanu's infamous extraordinary rendition from Kenya in 2021, wouldn't have happened. A lot of lives would have been saved, and the nation would have been more at peace. And we will not have the insecurity that we are grappling with today in the Southeast. And further to the decision of the African Commission on Human and People's Rights, the United Nations, through its special rapporteurs, transmitted a decision in 2020, May, precisely 2020, no, in October 2020, condemning the proscription, IPOB, and the terrorist tag placed on it. The quotations of what they said are contained in our press release, and they are verbose. But the summary of what they are saying is that the action of the federal government was driven by ethnic, some ethnic considerations against the Igbo, and that the action offended every known canon of international human rights law. Consequently, this organ, which is a very important organ of the United Nations, directed the federal government to do the opposite by deproscribing IPOB. That the action was never taken to get that done, and so here we have it, that for quite some time now, these things have persisted, and here we are with the dramatis personae, this most single factor in this whole saga is Nnamdi Kanu, who remains in detention to this day under questionable circumstances. At this juncture, I will yield to my colleague to my right, Barrister Nnamdi Ejimakor, to take you through some of the analysis of what I have said. Thank you. Prince Emmanuel Kanu. Yes, ladies and gentlemen of the press, what I said and what my two colleagues have said can be summarized as follows. One, recall that Nnamdi Kanu's case was commenced almost over 9 years ago, when he was first arrested in Lagos. Recall also that he was then charged with offenses relating to his broadcast on Radio Biafra from his location in London. You can imagine what it means for someone to be on an endless trial that never really happens for almost 10 years, and being detained without conviction for 18 months. Initially from 2015 to 2017, and again for over 3.5 years from 2021 to the present day. This alone is a gross injustice of its unique kind. Two, it's also to be recalled that after Nnamdi Kanu was freed on bail, Nigeria's army levied these lethal attacks against him that drove him into exile, involuntary exile, from which he was also renditioned in 2021. And recall the decision made in 2018 by the African Union that everything that has happened to the IPOB from 2017 to that very date, and of course, much worse happened after. Recall that those things were declared illegal and unlawful, and as having violated the African Charter at a continental scale. Now, also, the same action, in particular, the proscription of IPOB in 2017, provoked or triggered the rush of litigation that eventually culminated in the ruling of the High Court of Enugu State, declaring that such actions by the federal government of Nigeria against Nnamdi Kanu and IPOB are unconstitutional. So the question to ask is this: why is it that the IPOB, being of Igbo stock, it is not us as legal team making allegations? We have rulings of the international community. In the same vein, we have rulings of municipal courts in Nigeria indicating that what is happening to IPOB is nothing more than an ethnic-driven persecution. 3, now having survived the lethal attacks and having survived this many years in enforced exile, and having undergone all these tribulations and travails, and having been renditioned, these actions, this very action of the federal government of renditioning Nnamdi Kanu triggered the international legal order. In July 2022, the United Nations Human Rights Council came down with a gavel that Nnamdi Kanu was extraordinarily renditioned and that it was a violation of all canons of international law to which Nigeria is subject, and it recommended a generous compensation to be paid to him and cessation of his prosecution. That was ignored by the federal government. 4, it is noteworthy that on 29th June 2021, as indicated before, Nnamdi Kanu was arraigned. Well, you can say produced in court, albeit secretly, through the back door and presented before Honorable Justice Binta Moritala Nyako, who was aware that Nnamdi Kanu had cancel of record. The prosecution was aware Nnamdi Kanu had cancel of record, not us, his former lawyers. And the DSS was aware of the information of his cancel of record. Everything was on file. Yet, Nnamdi Kanu, or the court, conducted hearing over the head of Nnamdi Kanu and remanded him to DSS custody without notice to his counsel, not to talk of presence of his counsel. This is a flagrant violation of Section 36 of the Nigerian Constitution. 5, when you fast forward to October 2022, when the Court of Appeal discharged Nnamdi Kanu, there was also a judgment issuing from the Federal High Court sitting in Umuahia, which had declared his rendition from Kenya as unconstitutional. It didn't stop there. It went as far as declaring his continued detention in Abuja as unconstitutional. What will you do or expect a responsible government to do when the detention of her citizen is declared unconstitutional? You open the gates of the detention center and allow the citizen the free pass to go home. That's what Nnamdi Kanu deserved to have been done with him since October 2022 when that judgment came, but the federal government never did. That's part of the reason why we are saying his detention has turned extrajudicial and is no longer backed by any court order. 6, regarding the December 2023 judgment of the Supreme Court, which people are touting as having sent Nnamdi Kanu's case back to the High Court for trial, it doesn't end there. If it ends there, then it's a mischievous conclusion. The court went further. He said Nnamdi Kanu needs to go back to the High Court for trial, but it also said the High Court should not have revoked his bail. It also said that by revoking his bail, the impartiality of the High Court judge had become suspect. Ladies and gentlemen, you may not be lawyers, but when the apex court of the land tells a High Court, you should not have done this, what remains is for the High Court to do that which, or undo that wrong which he had done. And Section 287 of the Nigerian Constitution backs this up, because under that section, all subordinate courts in the country, or all courts in the country, are subordinate to the decisions of the Supreme Court. It never happened. 7. Now, talking about the much vaunted trial of Nnamdi Kanu, we raised objections to this trial too, based on the conditions of his detention, which were very stringent and highly prejudicial to his right to fair trial. This application was summarily denied and an accelerated trial was ordered in its place. We raised a second objection based on certain constitutional infirmities and statutory issues we noticed in the charges facing against Nnamdi Kanu. This too was summarily denied. So if you were Nnamdi Kanu, what will you do under the circumstances? To succumb to a trial you knew in your heart to be going towards the trajectory of an unfair trial or to seek alternatives to that. 8, having considered those factors which we enunciated, Mazi Nnamdi Kanu felt that the only fair way out of this logjam is to seek that his case be handled by another judge. Hence, the recusal, the famous recusal that is still roiling the system. And in concluding this press statement, ladies and gentlemen of the media, we must go on record to say this. As lawyers, our duty is to ensure that Mazi Nnamdi Kanu's case is conducted or handled in accordance with all the laws pertinent to it, particularly the Constitution of the Federal Government of the Federal Republic of Nigeria, which is the ground norm. In our view, this has not been the case, and the evidence is legion, as all who have dispassionately followed the trajectories of this case would agree. On this score, ladies and gentlemen, we make bold to state that this case has turned from the legal and the judicial to the political. This is perhaps the reason why there is a broad spectrum of persons and organizations calling for a resolution of this case outside of the judicial part, also known as political solution by baptism. These calls range from the international to the domestic, including members of the Senate, House of Representatives, the clergy, CSOs, eminent lawyers, and many others too numerous to mention. Be that as it may, and judging from 2015 when this case began 9 years ago, there is a trove of evidence that suggests that the only way to correctly describe what Mazi Nnamdi Kanu has passed through for almost a decade is to say that his case, even though bereft of merit from the very get-go, has turned from a trial to be conducted under the Constitution to a trial by ordeal. This is perverse and it will not stand. Thank you.
ndị be anyị kwadalụ dị na-enukwu nsi wee na-esore n'iru akwụkwọ gịnị ka i nwere ikwu gbasata maka ya bụ ife the special counsel and also the lead counsel of Mazi Nnamdi Kanu update o wetara anyị n'iru akwụkwọ ka ihe nwere ikwu maka ya bụ ife drọpụla ya na Eastern News 24 ebe anyị si wee na-ewetara ya bụ ozi a ka emesịa na ụmụnne